Hello. Estate litigations are complicated. And one of the reasons for that is that it's often a question of a hat, or should I say hats. Uh, one of the usual question in estate litigation is who pays for the lawyer who is representing the estate. And as a general rule, it seems to be quite a clear thing. Like the estate is represented by a lawyer. The estate hired a lawyer to do the representation, legal services, then the estate should pay. But often, uh, it is a litigation within the estate. Because one thing, if the estate is represented by a lawyer against some creditor or against some debtor or in any other like legal case between the estate and somebody else outside. But what if, for example, we are in the phase of the estate where, let's say, somebody's father or mother passed away, and in the last, let's say, 3 years, 2 years before that passing away, the parent was incapable, legally incapable. Therefore, there was a mandatory under protection mandate to take care of that parent, and let's say it was one of the children. Normally, when that person passes away, the mandatory should render an account for his or her administration to the estate. But what if the same person became now under the will the liquidator of this estate? And what if there was another child or some other children, siblings, who are also heirs and who do not trust this one who was the mandatory and now the liquidator? Particularly, they think that when their brother or sister, the liquidator, was the mandatory, he or she dilapidated the money of the person who was then incapable and now deceased. Uh, they need financial reporting for the period of administration, but it's within the powers of the liquidator, not the power of the heirs, to request that report and to discharge the mandatory. So technically, the person can release him or herself. Being a liquidator, one hat, releasing the same person but as a mandatory, previous mandatory, another hat. Let's add to that. Let's say that that person, when he or she was a mandatory or even before, uh, lent some money to that parent, maybe for the house repairs or for whatever reason. Or maybe it was vice versa, the parent who lent some money to that child, son or daughter. So now the estate should either pay back the money borrowed or should request the money borrowed from the deceased. But again, the estate is represented by the liquidator, and the other party, the debtor or a creditor, is like the same person, but hats are different. Debtor, creditor, um, liquidator. Let's make it even more complicated. Let's say that the person who is now the liquidator was not the child of the deceased person, but was his spouse, wife, husband. Then, by the Civil Code of Quebec, there is a question of family patrimony, which is the debt of the estate to the surviving spouse, to the widow or widower. And again, same person, but hats are different. The estate and the liquidator, as the representative of the estate, should pay the money to the same person, but as a surviving spouse. What if a significant part of the estate was left to their child, but the child is a minor. And a lesser part of the estate was left to the spouse. But the spouse, who is the liquidator and who is a mandatory, as we discussed before, is now not only the surviving spouse and the liquidator and ex-mandatory, but also a legal tutor to their child. So she or he is representing the child as an heir, uh, and so forth. So there may be many situations when the other heirs are suing that person altogether, and that person pretends that it's a litigation against the estate. So the estate should pay for all the legal expenses, for all the litigation expenses in such a conflict. But the heirs who sue that person might pretend that to a significant extent or just to a full extent, they're not suing the estate. They're suing that person not in his or her capacity as the liquidator of the estate, which would be an estate matter, but in his or her capacity as a debtor or creditor or legal tutor or, again, creditor as a surviving spouse for not providing some documentation or for acting not in the interest of the estate but in the interest of him or herself as another hat, another hat, another hat. So basically, it's a question of a conflict of interest. And well, in an ideal world, they would just get to some sort of an agreement, a compromise, of course. But like, let's say, semi-ideal world, the same person should be represented by different lawyers, like one for the estate and one for him or her personally. But the person wants the estate to pay for everything. So the person pretends that everything is an estate matter. As you can imagine, at the end of the day, this question comes to the judge, or at least the chances are high that it will come to the judge. And the judge, usually reading the invoices, the explanations given by a representing lawyer and expert reports and whatever was contracted and paid from the estate for this litigation, the judge will decide which part of it was personal, which part of it was about the estate. It might be even more complicated than I described. Let's say there is a contestation of a will, and under this will, the latest will, which is contested, this person is a liquidator, but under the previous will, which might become valid if this one is invalidated, that person gets more. So is it a conflict of interest? Again, a conflict of interest. And the question is if that person could be faithfully, diligently, impartially serve the best interests of the estate, meaning like respect to the last wishes of the deceased and the best interest of the beneficiaries, the heirs. It's always a question, and there is no simple answer to that. Usually it's a question of fact, and as a question of fact, if there is no agreement about that, it's for the judge to decide. So who pays estate lawyers? Estate pays as long as the lawyers are acting for the estate. But that's the actual question. Are the lawyers acting specifically and all the time only for the estate and not for the personal interest of the one who is the liquidator of the estate? Because, well, the lawyer is not hired by the estate in reality, but by the liquidator of the estate. That might be actually a difficult question for a lawyer as well, if a lawyer sees this conflict of interest. And it might be that the lawyer would request that the client finds two other lawyers because there is a conflict of interest, but that's another story. As you can see, the question is complicated, but it's something that should have been kept in mind, because sometimes a liquidator thinks that everything will be paid from the estate simply because that he or she is a liquidator. But again, as I started with, it's a question of hats. So the estate is paying for the liquidator as long as he or she is acting in his or her capacity as the liquidator. But for the other hats, the estate doesn't pay, or at least shouldn't pay. This is it. Thank you and have a nice day.